SJC-13051, Suburban Home Healthcare, Inc., v. Executive Office of Health and Human Services, Office of Medicaid.
Okay, Attorney Kelly.
Good morning. May it please the court, Brian Kelly on behalf of Suburban Home Healthcare. In this case, the lower court mistakenly found there was no statute of limitations in a situation where Mass Health is trying to recoup payments it made to my client almost 11 years ago. And that is wrong based upon SJC precedent, and here's why.
Counsel, before you get going, can I ask you, was there ever a moment when they indicated that the audit was over?
I'm sorry, well, the third-party vendor, when it sent its notice of audit to my client, said it would be over in 30 days. 30 days passed and it turned into 11 years.
Okay.
And this is not permissible under SJC precedent because you have to go back almost 40 years to 1979. You start with the Nantucket opinion. And that opinion is important to this case for two reasons. In Nantucket, this court found that if the statutory scheme does not discuss statute of limitations, that doesn't mean there's no statute of limitation. If the Nantucket court said that if the legislature wants no statute of limitations, it will say so.
So counsel, can I stop you there? Because there is a statute of limitations here, right? On some DA actions or the AG action. So given that the statute of limitations was addressed in the statutory scheme, why isn't it, it's not like Nantucket, I guess is what I'm saying. It's not silent.
Well, Your Honor,
one discussed.
We think it has no statute of limitations in this matter, and that's why the Superior Court went to Woodward. Here, as Nantucket says, you look at the essential nature of the claim. It's a contract dispute, and there's a whole series of cases, including.
But the statute of limitation wasn't contested in Nantucket. It was what the statute of limitation was, not whether or not there was a statute of limitations. But
in Nantucket, this court said, well, if it's not enumerated in the statute, you look at the essential nature of the claim. And if it's not enumerated in the statute, that doesn't mean the legislature says there's no statute of limitation. It would give an enormous advantage to Mass Health to not have a statute of limitations. In this court, I believe it was Justice Kafka just recently in December, in the In re Kendall case, said that when Mass Health gets a clear advantage, the legislature says so carefully and explicitly. That's what you recently held. And that's consistent with this whole line of cases, starting with Nantucket.
well, let me go to perhaps a weaker point for you. But I have to say, you did a very good job in your brief distinguishing the Woodward case, no doubt about it. And I won't go through all the different ways you distinguish it. But right there in Woodward, Justice Spina says the word action in Chapter 260, Section 2, has consistently been construed to refer to court proceedings.
Well, Your Honor.
And that's what, a 2006 case?
Yeah, but Woodward was a court proceeding. There were administrative action like here was in dispute in Zora and Anawan. So it's clear that administrative proceedings have this analysis applied to it as well. It's not just because Woodward was a civil case, that doesn't mean the rule doesn't apply in the administrative context, which it does under Zora and Anawan. And as the court suggests, Woodward is completely different. It's an automatic legal consequence there. And the language there was expressed. The legislature said in no event would a convicted legislator be entitled to a pension. So if the Board of Retirement wanted to wait a year, 5 years, it's just a ministerial act.
I understand, but the pension proceedings was not a court proceeding. The pension proceedings and the forfeiture of the pension, they indicated that it wasn't subject to the statute of limitations. And interestingly enough, again, Justice Spina, I understand referring back to some arbitration cases, I recognize that, but just came out and said actions mean court proceedings.
Well, Your Honor, I think that there's no indication that he meant to overrule both, or actually Zora and Anawan were after Woodward. So, maybe that was his view in 2006, but both Zora and Anawan were afterwards.
Yeah, so, but Zora is an adjudicatory hearing. It's dealing with the Ethics Commission.
This is an adjudicatory hearing as well. It's in front of the Board of Hearings. They sent their initial notice of overpayment in 2016, almost 11 years after the initial audit request for documents. So it's that initial notice of overpayment in 2016, which triggers the action. I think we cite in our opening brief at page 65, then in our reply brief at page 59, there's actually a Code of Mass Regulation which describes what initiates an action, 801 CMR 1.01 6A, again at page 65 and 59 of our respective briefs. And it can't just be an audit. That's asking for documents. It doesn't give the party notice that there's something wrong. It doesn't make a demand. It doesn't tell them that there's going to be a hearing later, as in order to show cause does, or as was done here with the initial notice of overpayment. That commences the action. And it's 11 years after the action accrued. They clearly knew about it way back in 2005. They sent an audit letter and they requested it, and they.
So counsel, I see that Zora and Anawem both go past the issue and the statements in Woodward and Schaffnacker that an action only refers to a court proceeding, and then figure out which of the statute of limitations should apply, given the nature of the action. What's your best argument to make Schaffnacker and Woodward consistent with those Zora and Anawem cases without just ignoring it? Because there are those statements, as Justice Lowy pointed out, that action means court action. And yet in Zora and Anawem, I'll grant you, they didn't even decide, reconcile that statement.
Well, I think the same principles would apply, because the same principles of fairness and of notice apply to a business or a client. They can't be at the mercy of the health for over a decade. So there's no reason, legal reason or policy reason even, why it should be different. The policy reasons favor a statute of limitations in this case. And it's consistent with Anawem and Zora. And here,
No, but I'm asking you to try to provide to us some rationale that could reconcile the statements in Schaffnacker and Woodward with the application of a statute of limitations in the other context of the other two cases.
I would say this: Woodward is a ministerial act by the Board of Retirement. It's an automatic legal consequence. There's nothing in dispute. The person's been convicted. The statute says you don't get a pension. Here, the dispute is still technically ongoing in the Board of Health. The facts haven't been decided. My client's disputing. The initial notice said $95,000. The final notice said $75,000. There's no finality. And that's the distinction with Woodward. It's an automatic ministerial act. And it's in Woodward cites both Nantucket and Zora. So it's not taking issue with those two rulings. And
Well, it cites Nantucket. I'll grant you that. I think Zora came after.
Yeah.
So if the rule is as simple as if it's an administrative proceeding, none of this applies, isn't all the verbiage in Woodward and all unnecessary? Couldn't they have just said, oh, it's an administrative proceeding, no statute of limitations ever applies there? Couldn't they have just done that if it were that easy?
No, because I think in the Nantucket case, which again is the seminal case that leads into this all, it talked about if the legislature wanted to say there was no statute of limitation, it could do so. Just like you recently said, if Mass Health wanted to be advantaged, the legislature can do so. So consistent with that, Nantucket said if there's an express intent by the legislature, you have to follow it, of course. And that's what Woodward did.
Yeah, Mr. Kelly, I'm sympathetic to your argument. I just find that our two strands of case law seem inconsistent with each other. There's the one strand that you're focusing in on, which is we look at the statute, we look at the nature of the action, and then there's this other Woodward strand where, as a preliminary step, we draw this distinction between administrative law and court actions. I'm just wondering whether they're irreconcilable, or is there a way of making the two different strands make sense the way Justice Wendland was asking you? I just can't tell whether you can.
Yes, I don't think Woodward was considering the administrative context because it wasn't in the administrative context. So I don't think it's necessarily in conflict with Zora and Anawan.
Well, they're quotes, you know, I tracked through that language in Woodward in the Supreme Court cases and the arbitration cases. You know, there is this statement that says statute of limitations apply to court actions. And I don't know if it makes any sense. And when you actually look at what they looked at, they're really these very old equity cases and some others and arbitration stuff. But I'm just wondering whether we can reconcile these two strands of
I think you can. I think the court may have been saying it applies to court action because that was in fact a court action. And they may not have felt the need to also expand upon it and announce a ruling on an issue not before it, i.e. the administrative proceedings. Whereas
Can I push
that
you
was
to a different issue, which is I'm trying to, you know, Justice Wendland's point that there is a statute of limitations here for the DA and the AG actions, but there's not an express one for this type of, you know, administrative action. But at the same time, it uses the same 6-year language for the audit, right? Retention of records is for 6 years, right?
Yep.
Why didn't, yeah, I'm just trying to figure out how I'm sympathetic to your point that this looks like a 6-year statute of limitations, but at the same time, they didn't just include this proceeding in that 6-year statute of limitation provision. Couldn't they have just done that?
Well, they could have, and it would have made it clearer, but that's not the initiation of the action. It's the initial notice of overpayment, which commences the action. And that's the one that's 11 years, almost 11 years after the audit where they were on notice.
But why didn't they just say that this process itself is covered by the same 6-year statute of limitations? We just, you know, define the time period, the commencement period differently.
Well, you know, I'm not sure why the legislature did what it did, but the essential nature of this case is clearly contractual. In the record appendix at 23, you see the provider agreement. It talks about consideration, promises, mutual agreements. This is a contract matter, the essential nature is, and therefore it should be 6 years. And therefore they should be barred from trying to collect on claims that are so old because
Well, that's the answer. That's not the question. The question is whether, you know, recoupment action is based on the contractual relationship or is really the essential nature of this relationship between your client and Mass Health contractual. And of course, you know the brief. They've gone through the different cases, including Centennial, as to why it's contractual. Why is that wrong?
Well, because those cases, if there was a federal regulation.
I mean, it's statutory, that it's a statutory relationship. That's their position. And they,
Well,
go ahead, I'm sorry.
I'm sorry. If there's a federal regulation on point about the statute of limitations, it would control. But there's nothing on point. So that's why common law, this court's opinions.
No, but they're saying it's the whole relationship and the whole manner of payment between the provider and Mass Health is based on Chapter 118E. And so put aside our incomprehensible 2 lines of cases that we've spent a lot of time on and go to, I think, your point, the nature of the underlying dispute. Why isn't, if we look to the relationship, this relationship governed from A to Z by the statute?
Well, because my client provides home health care services pursuant to a provider agreement, Exhibit 1 in the record appendix. That's a contract with the state, and the state pays it. And if the state decides it's overpaid it, first they investigate it. They have this algorithm that tells them there's a red flag. They send an audit, and then they tell you through.
But that scheme that you're about to describe is all in the statute. The question I think that Justice Lowy is asking is why is this not a statutory? The core nature of the dispute here is statutory, not the contract. The contract just says, hey, you have to abide by the statute if you want to be a provider.
Right.
Because there's nothing in the statute that says there's a 6-year statute of limitations. It's silent. So you go back to saying, well, the legislator could have decided that there was no statute of limitations. It would have said so expressly like it did.
So
in
your argument is that because the statute doesn't say there's a statute of limitations, the nature of the dispute is contractual?
Yeah, almost until the end. Because there's nothing in the statute that talks about statute of limitation, you have to look to the essential nature of the claim. Could be tort. For instance, Nantucket, I think, was in tort.
Yeah, and I guess that's my question, that second part. So tell me why the essential nature of the claim is contractual.
Because my client signed a contract, a provider agreement with Mass Health to provide services. It did. Now Mass Health, over a decade later, is trying to claw back some of that monies when we can't get all our records together, which, by the way, it is in the record appendix at 65, contrary to the Mass Health's brief. We can't gather all our records. It's just common sense to think that after a decade passes, memories fade. So it does prejudice us. You see my time's run out. But it does prejudice us. There are strong policy reasons. There should be a statute of limitations here. So I know latches, we've briefed it. I'll rely upon the brief.
Before you leave that, can I ask with Chief Justice Budd's permission, one last question? Can the feds make the state give back money more than 6 years later? Because the statute of limitation, I remember the intersection between the federal and the state being extremely complicated here. Can the feds demand money back more than 6 years after it's been paid under the federal statute?
It appears the feds can once it's decided. I mean, this still hasn't been decided, but that's a battle, so to speak, between the feds and the state. It's not between the state and the service provider, because we have a contractual relationship.
Well, I'm just trying to figure out whether the state could be on the hook for money that you're saying the statute of limitations precludes the state from going after the provider. Is that a possibility here?
It is a possibility, but that's another reason they should be incentivized to do these audits and make these recoupments earlier than a decade later. The taxpayer has an interest in getting this money back, and the state has an interest in having the money to pay the feds. So there should be a statute of limitations and a policy grounds for the taxpayer, as well as the businesses who's going to go into this business if they can be on the hook for claims 20, 30, 40 years later. And that's why latches, again, we've briefed it, but if in any case the doctrine of latches applies, I think it applies here because, again, Mass Health is asking you to say, hey, they can wait 10 years, 20 years, 30 years. How about half a century before they try to recoup payments from these private businesses who are in a difficult space? There's not wide margins. They service people who have all sorts of medical problems, and you're going to drive companies out of this business if there's not some certainty. And I think a statute of limitations would provide that, and the statute of limitations is required respectfully under SJC precedent. So I apologize for going over. Thank you for your time.
Thank you. Okay, Attorney Marks, you've heard Attorney Kelly's argument. Tell us why there should not be a statute of limitations here.
May it please the court, David Marks, Assistant Attorney General for the Executive Office of Health and Human Services and the Massachusetts Medicaid Program, Mass Health. Before I reach the merits, just a word on exhaustion. The case should be dismissed because, as a matter of subject matter jurisdiction.
We all are exhausted. Can you answer Justice Budd's question, Chief Justice Budd's question?
The Superior Court correctly determined that the 6-year statute of limitations in Chapter 260, Section 2 did not apply to the administrative regulatory proceedings that the statute and the regulations provide Mass Health go through in order to identify.
So what is the upper limit? Can you wait? Can you tag the provider and say, hey, I'm going to do an audit 50 years later? Oh, guess what? You owe us $100,000. Is that really your position?
Position is that, and the statute is clear on this, the legislature did not impose a limitations period on this process.
So yes, your answer is yes, that is your position, that you, so long as you tag the provider within the 6-year window for retaining records, you can come back 10, 20, 30, 100 years later and ask for your money back. Is that your position?
Well, as a practical matter, first of all, yes, the regulation that requires maintenance of the records for 6 years.
Uh-oh.
Uh-oh. Almost.
Attorney Marks is re-entering the courtroom.
Attorney Marks, you're back with us.
I am. I lost my
Remember what-
connection.
Yeah, no problem. Do you remember what question you were answering? It was
Why
about
should I win it? Why should I win this case?
Yeah, that one.
The answer is that number one, the statute of limitations in 260 Section 2 does not apply, as the Woodward case said, because it only applies to actions, courtroom proceedings, and that's not what this is. This is an administrative regulatory process.
Well, let's say, as we've talked about a little, that our cases seem to go in two directions there. So we need to figure out then whether this recoupment action is more a function of a statute or contractual. And I know you point to the language right in chapter 118 and where the provider agrees to be responsible for overpayment. But why isn't Mr. Kelly right? This is, take a step back, it looks sort of simple. You paid them money for services, and now you're saying they owe some of that money back because they overbilled? Isn't that just core contract stuff?
First of all, it's not necessarily true that there are two lines of analysis that this court has entered into. Both Zora and Anawan were decided on the basis of an agreement, if you will. The parties agreed that a period of limitations would apply. The only question before the court was which period of limitation. The courts there.
How do we know that, Mr. Marks? The briefs say that we agree a statute of limitation applies, we just have to figure out which one it is? Or did the court just assume when there's a lack of clarity, including in administrative processes, we have to figure out what statute of limitation applies?
In Zora and Anawan, the decisions, this court's opinions make it clear that the parties agreed that a limitations applied, and the only question in the case was which period of limitations apply. This court did not decide whether the 6-year statute of limitations in 260 Section 2 should apply to administrative proceedings. So
I don't find that, but I'll reread those cases. But how about, so if you're right, why didn't Woodward stop after one sentence? This is an administrative process. Statute of limitations don't apply. Instead of, 20 pages of all this sort of back and forth of why there's no statute of limitations there. Why couldn't they just say, oh, this is simple. Admin is outside the statute of limitations context.
well, I think that this court likes to be as explanatory as possible. And this court's next point in the Woodward case, which is that the action in contract that Woodward in that case argued applied, the legislature specifically did not call this aspect of the retirement law, pension forfeiture, a contract action.
Right, but we don't have that. I agree. The pension law breaks things down to what are contract rights and what are not contract rights. We don't have that here. We don't have, this is a contract under Medicaid, this isn't, right? We don't have that language in here, do we?
You absolutely do have that here.
Where?
Here, the legislature specifically said in section 44 of Chapter 118E that there is a 6-year statute of limitations on the Attorney General's pursuit of actions in court seeking to establish violations of the Medicaid law. In sections 36 and 38 of Chapter 118E, which the legislature provided for determining overpayments by providers, there is no provision for a statute of limitations. As this court has said, most recently in the Estate of Kendall case, the court will not read into the statute language that is not there. And that's exactly what the Woodward case said as well, where the legislature referred to a limitations period in one section of the statute, but does not refer to it in another section of the statute. The legislature did not intend to impose a limitations period.
But Mr. Marks, you know, there's a lot of unfairness going on here, and Woodward didn't have that problem. There was a criminal trial, and there was proof beyond a reasonable doubt as to the representatives. And as Justice Kafka said, it wasn't just one line. They went on for another 20 or whatever pages. Here, you have just the opposite problem. This case is dripping with unfairness. Where are the witnesses? Where are the documents? This started in 2005 and 2019. We had a final decision. So Woodward is in a lot of ways, despite that one line of perhaps dicta, apples and oranges.
I'm sorry, Your Honor, there is no unfairness here. Let me explain why. The legislature did not intend for there to be a limitations period on Mass Health's process of identifying overpayments. Number one, it did not say so. Number two, in section
But
36,
that doesn't go to the issue of fairness, right? I mean,
it goes to the
that was
issue
my
of
question.
legislation.
That was my question before we had the technical difficulty. Why is it fair for Mass Health to be able to tag somebody in year one, wait 20, 30, 40, 50, 60, 70 years later, finish its audit and say, I want our money back? Why is that fair?
The question is, did the legislature intend to impose a limitations period?
Right. And so the issue of fairness you're saying is besides the point.
The law does not enshrine the question of fairness here. There is no reason to believe.
Then why did they have the 6-year provision on keeping records? And why does that track the 6-year statute of limitations language? Don't we have a lot of similar quacking going on? It looks like a duck, it quacks like a duck. There's a lot of 6 years in here, and this also all originates out of a contractual relationship.
Again, Woodward itself talks about this, where.
But just ask the specific question. Why did they have the 6 years on the audit? Why do they have the same 6-year provision elsewhere in the statute in the part that you're dealing with? Why is it there if basically, as Justice Wendland asked you, in the year 3000, you can come complete your audit?
The 6-year provision is in the regulations. It requires the records be kept for 6 years, but it requires the records not be discarded if within that 6 years, there was an ongoing investigation, an audit, etc.
Does the statute have a 6-year provision related to this audit, the administrative process, or is it only in the regulation?
I think it is only in the regulations. I do not think the statute has a specific provision for how long records need to be kept.
It's just the regulations.
So if you're right about our law as it relates to court actions, and you're right about the nature of the relationship being governed by Chapter 118, I know that laches is not something we really talk about in terms of against the government. We do have that Weiner versus Board of Registration of Psychologists. Are there situations where the outcome becomes so ridiculous that we should have a very, very narrow exception to latches against the government?
Well, first of all, laches does not apply here because it's an equitable remedy. There's no issue of equity here. This is an
He may just have to forfeit that last.
administrative public interest. However, in the course of an adjudicatory process could raise these kinds of issues. Prejudice, I got rid of the records, you led me astray. Those could be raised in the context of the administrative proceedings and during the administrative adjudicatory hearing. And clearly there is a difficulty if a provider no longer has the records because after 6 years they properly discarded them. There is no evidence of that in this case, and there is no allegation in the complaint in this case. The reasons the legislature does not want to see a statute of limitations in this context is because, as this case observed in the Atlanticare, this court observed in the Atlanticare case, this is a pay and chase system. Under federal statute or federal regulations, that's 42 CFR section 447.45, a state is required to pay Medicaid claims within 30 to 90 days. And a state's ability to determine whether there is an overpayment depends on a state's retroactively reviewing the records of a provider and then determining or discovering
six years isn't enough to get your homework done?
The other reason the legislature would not intend to apply that limitations period is because the federal government does not have a limitations period.
So the feds can come in 10 years from now and say, what provision in federal law says that? I'd like to read that.
The federal law, okay, so the notion that the federal government has no limitations period upon which it can seek return of overpayments from the state is in departmental appeals board decisions. The CMS has this thing called the Departmental Appeals Board, which is an administrative hearings process where it reviews instances in which the federal government has disallowed payments, the federal portion of payments made to states, where the federal government says that the state has overpaid a provider.
And there's no statute of limitations on federal recoupment.
That's right.
In Justice Wendland's hypothetical, in the year 3000, they can say to you, you overpaid in the year 2021, turn it over to us. They can do that?
Yes. Yes.
And what's the provision that provides, because when we have to dig through these Medicaid laws, they're almost incomprehensible. Which particular provision, do you know that? And if you don't, I'd like you to send a 16L letter indicating which provision allows the feds to recoup in this delayed fashion.
The Departmental Appeals Board cites, among others, 42 CFR section 433.316 and 42 CFR 430.42. There's no express language in these regulations that says how long the federal government can take. There's no limitation in these regulations. So what is important is, again, If the
Hold on,
federal
wait, I'm
government,
sorry, Attorney Marks, I'm gonna just, if you're gonna reiterate something, we've got it. So thank you. And we'll take our morning break.